Hello, Cameron. Welcome to Foreign Connect podcast. Thank you very much for coming to the show today.
Thank you, Natsuni. It's a pleasure to be with you today.
Yes. So to start this interview, I wanted to ask you what your background is as a lawyer and also a business developer. Can you tell me where you work right now? What have you done and so forth?
Yes, Natsuni. My name is Cameron Tousi, and I'm the managing partner of IP Law Leaders. It actually stands for Integrated Professional Law Leaders. One of our key areas is intellectual property law. Another one is technology-oriented business law. So our law firm represents very much businesses, especially at the startup stage and mid-sized businesses as they're growing. I myself have about a quarter of a century of experience. I have done just about everything as you might imagine, from multi-million-dollar litigations with very big settlements for clients, both in IP and in the business-oriented IP related law. I do a great deal of procurement, meaning trying to get intellectual property for companies, whether it's patents, trademarks, copyrights, trade secrets. Sometimes we have many issues in that area. We do a great deal of technology-oriented law. And by that, I mean, we do help corporations to get incorporated and formed, as well as trying to distribute, make key questions that a company has, like distribution of shares, how to deal with venture capitalists, although we've represented both sides. We've represented both the investors as well as startups in that area. It's a very thriving practice. I'm very happy. I formed the firm in 2012. So we're kind of a startup ourselves, if you think about it. That's how we operate as well. All of our lawyers had decades of experience before they joined us. That's the same with me at some of the very big firms where I think you get good experience. One of the issues was that, when you're trying to represent, especially newer companies and companies that are just looking to grow, they're very cost sensitive. It's not as easy for them to dig deep and pay as much for legal fees. And so we thought this was a good opportunity to serve them and serve the entrepreneurial community. And I myself have recently formed a podcast too, just to be able to talk to entrepreneurs. Yes.
That's awesome. What's the name of the podcast?
It's just named after me. It's Cameron Tousi Podcast, but its focus is on entrepreneurship. My name is Cameron, and my last name is Tousi.
Okay, perfect.
Be on the lookout for it. It's getting released in August. So
sounds good. We'll make sure to list that also in the show notes.
Thank you.
So with that being said, you kind of explained also like a checklist. Well, I guess the variety of the service areas that you provide within law, right? But I want to know if there's any sort of like a checklist you prepare for companies.
Well, I have due diligence lists and checklists, and if your listeners are welcome, if they get a hold of me, and I can provide the specific checklist, but I can describe some of it for you here.
Okay.
So an easy way to get a hold of me, if you go to IP Law Leaders, IPLAWLEADRS.com, or email me, Cameron@IPLawLeaders.com. I can provide the very specific due diligence or checklist as required. I can explain to you some of what's required right now in terms of our conversation. So if you're bringing a corporation to the U.S. or you're just starting it for the first time, you're really going to be concerned about three main areas of law. One is obviously going to be the corporate law, because you're going to have to worry about, if it's owned principally, let's say in Japan, and you have that's where the mothership is, and then you have joint ventures with a company in the US, or you have a parent-child type of relationship. So you're going to have a subsidiary, et cetera, in the US. You're going to worry about what exactly are those relationships, and how are these companies connected, meaning where is the distribution of the control of the companies? Is there enough independence to be able to operate in the U.S.? There's going to be an enormous amount of time spent on, compliance, depending on what your particular area is. Like, for example, if you're in communications, we're going to have to make sure that you're compliant with the FCC regulations. If you're in pharmaceuticals, et cetera, every one of those, you have to make sure that you have the legal compliances required. That goes along with the corporate end of it, as well as the third part of the corporate side of it, if you will, are the transactions that you do. Those are the day-to-day contracts, the bread and butter, if you will, of having companies do well by continuing to get additional transactions and grow the company. That's that kind of day-to-day activity. You're going to want a transactions lawyer who's very much on the spot with you, so that if you need immediate help, they can jump in and start negotiating agreements for you, or at least provide a template so that you can conduct your business. Okay. And the second big area is going to be employment law. Employment law in the U.S. is going to be obviously different than in other countries. As a matter of fact, our law firm does some employment litigation where we represent corporations that have run into some issues there, because the corporate laws, the employment laws back home may be different than what they are in the U.S. And typically they very much are. And so we have to just make sure that there's compliance, and that what's interesting about the U.S., by the way, Sunny, is that in the U.S. you have 50 states, and each has its own separate jurisdictions. So you do have a federal jurisdiction that oversees all of it, but you also have independent state jurisdictions as well. So even if you have compliance in the U.S., let's say an employment law with, what you think is, the federal law, each state's going to have its, and each city even is going to have its own different kinds of laws or regulations regarding how employees are being treated, et cetera. And you have to be careful of it, because, you can sometimes hit spots where people are just very litigious. We've had incidents of somebody working at a company for a few weeks, and next thing you know, they have a big lawsuit on their hands. So it's very important for your listeners to be mindful of that, and be getting the employment advice. Of course, that's an area that we cover as well, depending on the jurisdiction and the kind of work that's required. But even at a startup stage, at a very early stage of development for a company, you've got to be cognizant of your employees, what's the ownership or not of, for example, IP. If you have a startup company in technology, if you've got in high tech or biotech, et cetera, some of the core technology that you develop is going to be a key asset of your business. You want to make sure that's all protected. But remember, you also have to be careful that the employees who work for you are not able to just sort of quit and take what they've developed elsewhere. That's where a lot of problems happen. That's where sometimes you get trade secret litigations or patent suits and all these kinds of things. But you do have to worry about, do you really own that IP? That's a very key aspect of the employment, particularly for startups. And again, in the U.S., the states vary. California, for example, gives more, I would say they're kinder sort of to employees in terms of what type of IP they get to keep versus some other states. Okay. So like New York, for example. So it's really good to be mindful of that you've got to make sure that, that's really part of the equation for the employment aspect of the legal endeavors that, you're helping for corporations. Okay. So, and the third part of it, as I've already touched on, is the intellectual property of it. That's particularly important if you've got companies that, they're in software, hardware, biotech, pharmaceuticals, all these areas where the technology is key to your business. You want to make sure that you have a good, due diligence checklist, which, we do with clients. And you've got a good rundown and an understanding of what needs to be protected and what type of IP or intellectual property is used to protect it, be it patents, copyrights, trademarks, trade secrets. Those are being the four key pillars of the IP protection. And so again, with our firm, what we do is we basically create like an internal patent filtration committee, particularly for the technology companies, where we're helping the client assess what key areas of IP is it that need to be protected and what's our strategy for it. You should also have early on, instead of waiting till later, a licensing strategy as well as litigation if you have to go there strategy, right? Litigation is something most operating companies would like to avoid, but you have to be cognizant of the problems that may be created early on, right? So for example, if we're helping a company develop its patent portfolio, we want to make sure that the patents that they develop are litigation tested, they're litigation ready. The reason is because if you were to take the IP that you protected by virtue of, some strong patents right now, right? And if you wanted to get a patent license with another company, guess what they're going to do? They're going to hire an attorney to look to see how strong those patent claims are and how strong the patent itself is and how enforceable it is, okay? So they're going to be taking a look at it just like you would if you were in a litigation already, okay? Now, if it happens that the parties cannot come to agreement, you're not able to, as an enforcer, is not able to collect his funds, or defender thinks that, these patents are worthless, we don't want to pay anything on them, you end up in litigation. It's just think of it as a continuation of your settlement strategy here, because patent lits in particular, I mentioned patent lits because I'm talking about technology companies, but these kinds of suits in particular settle, vast majority settle, over 90% It's just a matter of how they settle. I can go into a lot of the specifics of that for you, but I just want at this high level that there would be an understanding that whoever is crafting your IP portfolio should have a good awareness and understanding of how to test it and make sure that it's litigation ready, even if your ultimate goal is just to use the patents defensively or to license them, and the last thing in the world that you want is litigation. The US is a very litigious country, and you always have to be mindful of that. I think that's actually one of the key differentiators of our firm versus others, because the people who are drafting your applications are working in teams with the litigators, and many of the people who even draft and prosecute the applications. Prosecution, by the way, Sunny, just means that trying to get a patent for someone. It doesn't mean that you're putting anybody in jail or anything. But the prosecution of the patent application, that type of work is done by people who are doing litigation or are in very close teams with people who are doing litigation. And I think that's very much of a differentiator in terms of the overall offerings that we have. I have recommended, and this isn't just an advertisement for my firm, I recommended this to other lawyers as well for many years. And just because I've been in this industry and I've just seen a lot, and it's just from the voice of experience, you'll have to trust me.
Oh, I see. Well, I mean, this was a lot of very insightful information, but now I'm a little bit scared. Like, can you tell me when companies should look into hiring lawyers when they want to first enter American market?
Well, first of all, I didn't mean to scare you. It's it's kind of like, I guess it's a lawyer's job to scare people, and then that's how they make their money or something. But but there's a lot to be careful about there, So think of as a lawyer, their job is to sort of keep you out of trouble, make sure that you have the freedom to do what you need to do. You know what I mean?
Yep.
In terms of, I think you're asking when should you bring your counsel in? I think the earlier the better, because the issue is that if you might be doing things without understanding some of the repercussions involved. You know what I mean?
Yeah.
So for example, let me give you one very small example in the IP field in particular.
Okay.
If I recommend, like, if a company thinks that another company is infringing its patents, it's natural to send a letter to that company and say, stop infringing. It's called a cease and desist letter, you know? And sometimes these are written very harshly, et cetera. Now, if you have someone who doesn't know what they're doing, now that could be because, you know, you're this great business person, but you don't understand the laws, or maybe you're working with an attorney who is more of a general practitioner. They don't know the specifics of it. They might just go ahead and send that letter without thinking carefully about it. Now, the reason you want to be thinking really carefully is because in the US, by sending a harsh letter, you might be creating an opportunity for that other party to sue you. It's called a declaratory judgment action. That means that if I threaten you with something, then the question is, are you able to sue me first? The reason you might want to sue me first is say, look, this guy won't leave me alone. I want to prove that I'm innocent, right? I want to prove that I'm not infringing. I want to prove that I have, and so you can bring the suit first. So it's like think of it as like a defendant, a potential defendant bringing a lawsuit. Now we call it declaratory judgment action. Okay, DJ. DJ is mentioned a lot in our parlance. The reason you have to be careful is because you might be sending a letter to a company and it's going to want to sue you in its own background, its own backyard, meaning at a court that's closer to it, because it's going to think it's going to get a more favorable jury or a judge or treatment, or the general public likes them more. It's a major company in that area, et cetera. So all of a sudden you've lost the battle of the forums, the battle of the venue. Where is that suit brought? Okay. So just by something as simple as sending a letter, you might be creating a potential litigation against yourself, whereas one didn't even exist. You were looking to just send a letter and tell these, to these people to either to stop infringing or to sign up for a license agreement. So what I'm saying is, even in that very specific little example, you've got to be really careful. Now, in particular, if a corporation is looking to build a subsidiary in the US, or if a startup is looking to get, these are just two examples, is if a startup is looking to get going and develop itself, you've got to be careful, because, you have to be thinking against, regarding all the rules and regulations I mentioned. Are you entitled to operate this company? Do you have all the licenses that you need? Are you incorporated properly? Have you given, for example, all your assets to the wrong person? I mean, have you distributed in crazy amount of shares in a way that you're not going to be able to take back or walk back later? How are you dealing with your angel investors? How are you dealing with potential VCs that'll come in the next round? How much control is kept by you? Remember that a lot of times with startups in particular, there's a distribution of preferred shares. So these are shares that, even though somebody may have a smaller number of shares, they may have much more control by virtue of having these shares than other regular shares. Okay. So if you have, and what happens very often, probably more often than not, is that when a venture capitalist works with a startup company, they're going to want some special preferred shares for themselves. And those shares will, for example, entitle them to be paid first once there are revenues versus owners of other shares. A lot of times it's about control. If the shares may give them an opportunity to take control of the company if it's not going in the right direction, or making the revenues they want, et cetera. These things have to be thought out very carefully, whether you're on the funding side of it, and especially if you're somebody who's just got this technology or something else that you're looking to expand and develop and grow, that you afford yourself the proper amount of, at least if there's going to be some preferred shares, that you afford yourself, an even kind of an opportunity. That you make, remember, every word of a contract is going to be negotiated between the two sides. And the difference between something that's going to really protect you and something that really may not may come down to just a few words in that agreement. Okay. So one of the recommendations also that I make is, remember, there's going to be a valuation of corporations early on, especially when you're bringing funders and investors on board, right? So there is going to be some grappling over, whatever assets I bring to the table. Let's say I developed, this really cool technology, really valuable, et cetera. I want that to be properly valued when we go into negotiations with investors. Okay.
Right.
So a lot of times people that are more seasoned and more experienced, what they're looking to do is to have a better valuation, but also they might spend more time developing that before they bring really principal rounds of investors in. Okay. So why? Because you want to get a bigger valuation. You want to say that what I brought to the table is worth more and be able to get a better dollar value for what you're bringing to the table. Does that make any sense?
Yep. But it's very high level, to be honest. But this is very insightful. I really appreciate that you share this information with us. So finally, I noticed that you also have your own experience leading venture-backed startup, right? And perhaps this is probably one of the competitive advantage you have against other lawyers too, because maybe some lawyers are more like a generalist, as you mentioned earlier. Can you tell me the experience you had when you were leading the venture-backed startup yourself as well?
Well, let me put it to you this way. The startups that I've had, what we did, I'm sorry, if you can. What we did with these startups, we actually were able to bring dollars to the table from the corporation that was sponsoring us. So I don't know if you follow Gary V or Gary Vaynerchuk at all.
Yeah,
but I'm sorry.
I do. Yeah.
So one of the things that he's mentioned, which I agree with, is it should not be, a chest pounding moment of great pride or anything when you're borrowing money. It should be a sad day for you because you got to pay that back and everything. So I know a lot of times that young entrepreneurs think that the only thing I really need to do, as soon as I get that funding, I'm set, I'm done. It's not really the case. That's really where your task begins. And you don't want to be borrowing funds and you're not going to be able to pay back properly or be able to build this company well. Right. So you've got to have a really good game plan, which is what we did. I had one company I was a co-founder. The guy was the principal founder of it. We were doing marketing in the NASCAR world, which is NASCAR, which is an auto racing in the US, because it's kind of a big industry. Our principal focus was on the marketing end of it. But we also had a racing team as well. As a matter of fact, we were one of only 4 teams that were we were one of 4 teams that had, we got Toyota, the first time a Japanese manufacturer ever got into NASCAR. Wow. We were one of those 4. We actually got them their very first win, believe it or not.
Wow.
So,
that's amazing.
that's right. You didn't know I had a relationship with Toyota. You should also know that for many years, I've worked on IP matters for many, many Japanese companies at law firms, et cetera, from you name it, NEC, Mitsubishi,
wow.
many, many of these corporations.
Wow.
And I think that any of those companies want to talk to me now, the IP landscape is completely different than it used to be. You have to change your operations regarding that. Yeah. So I'm happy to talk about that. But anyway, that's the venture that you're talking about. A lot of it is from, I'm an advisor to startups. I also, as a legal advisor to startups, I help with that. I also do the same work as a regular attorney, advising. So I've probably seen a lot more of it than maybe your average entrepreneur. But when I was doing the business myself, those elements were just a lot more key because then it's, it's your own money, it's your own assets, and you're always worried about it.
I see. Well, thank you very much for coming to the show today. We had
My pleasure.
A lot of valuable information from you today, so I really appreciate that. So before I let you go, can you tell us where people can find you?
Yes, if you go to iplawleaders.com, iplawleaders.com, or you can even email me, Cameron, Cameron, @iplawleaders.com. You're welcome to get a hold of me that way.
Do you have any social media? Yeah, sorry.
Yes, there's a lot of social media. If you look up IP Law Leaders, it should come up.
Okay.
So we have we're big on Facebook. We're everywhere, YouTube, etc. And I have a new podcast, as I mentioned, coming up. So if you Google podcast, my name, it should pop up as well. But yes, we're quite active, like you have to be these days, right?
Right. Yeah, on social. Yeah. Well, perfect. Thank you so much.